Anim, Winabujo, Christa Big Canoe, Indigenous, Noden Kwa, Anishinaabe Kwe, Biggie Dorum, Georgina Island Danjaba, Ogima Kwe, Ganoon Majig, Gakina, Wabama, Debuiwin, Miigwech, Jemago, Nokumisik, Shosumisik, Anishinaabe, Mississaugas of New Credit, Haudenosaunee, Huron, Wendat, Algonquins, and the Law Union for having me. So the introduction is already done. I basically just said in Anishinaabe when who I am, that I'm from the Alder clan, that my First Nation is Georgina Island, and that I am, because there's no way to translate legal director, I'm sort of like the chief lady of the lawyers. It's always a pleasure, and Audrey had already acknowledged that we're on traditional territory, but it's always a pleasure to introduce myself in Anishinaabe when we're in traditional territories, particularly traditional territories of my people. When we speak of our people, we remember to give them some reverence and respect, and a good way of doing that is opening in a good way. So, today's topic, when you read the description, you're like, holy man, how are we going to cover this in an hour and a half? Because when I say, holy man, how are we going to cover this in an hour and a half? In preparing my notes for today, I actually went through a number of things that ALST has done, and particularly even I've done, in terms of making submissions to various levels of government in regards to the various legislations and the impacts they've had, particularly on Aboriginal people, and more specifically on Aboriginal women. And so I've only chosen a handful of them, believe it or not, and I didn't print all of the briefs off, but that's 3 briefs and some information about Bill C-36. That's not even, it doesn't scratch the surface of the material that we reviewed and put into briefing notes for Senate, for parliamentary, for Ontario legislature, for municipalities. And so essentially the things I want to focus on today on a very high level, I realize I forgot to start this line, on a really high level, are a few of the things that have happened in the legislative landscape. And if you've heard me speak before, you've heard me talk about the toxic legislative landscape that exists for most Canadians, but particularly the impact it has on Indigenous people. And so, I'm going to start with an overview. Since being an Aboriginal legal service, some of the stuff that we have done and that I've specifically done has started with the truth in sentencing. Because the truth in sentencing legislation that came into place looked at calculating the time somebody is in custody prior to actually being sentenced and what the value for that is. And the truth in sentencing legislation changed that landscape. And anytime we talk about criminal law in this country, we cannot ignore the fact that there's a huge overrepresentation of Aboriginal people. In particular, there's a huge overrepresentation of Aboriginal women. So in federal custody, 3 out of 5 women in federal custody are Aboriginal. So to ignore any type of legislative change or any legal changes as it relates to criminal law is always very difficult to overlook. So the truth in sentencing was one. Then of course the big one was the omnibus. And we literally spent a year and a half doing public engagement, speaking, working with a lot of our partners, including the Law Union, to talk about the impact the omnibus was going to have as it worked its way up through the readings. And essentially we did make submissions before the Senate Standing Committee on the Safe Streaming Communities Act. Again, the implications and the changes within that, and we can't even, in the short amount of time we have today, I can't even begin to tell you like a comparative of where the law changed and what impact that would have. It's safe to say that when the omnibus went through, it took the tough on crime attitude of the Conservative government. It pushed through legislation that, despite tons of experts, despite tons of information, made very little modifications on its way up through the reading and to the Senate Standing Committee itself, and ended up pushing through legislation that has a huge impact, an impact that arguably won't be reversed easily even if there was a new government put into place. And then of course we saw Bill C-393, and this was one that's not discussed so much in circles, even with Law Union colleagues, but it was the Act to amend the Criminal Code and the National Defence Act, specifically as it relates to, the criminal organization and recruitment. Some of the provisions that were amended in the Criminal Code and the National Defence Act, now that we see Bill C-351, seem like nothing. But at the time as they were pushing this through, essentially they were trying to make longer sentences more strict sentences, and mandatory minimums for people who had gang involvement. Ironically, again, from an Aboriginal perspective, both for men and women, the gang infiltration into our communities actually starts in custody, by and large. So as individuals find themselves federally incarcerated, what they find themselves happening is a network of their inmates, their fellow inmates, is the first interaction they actually have with gang involvement. Canada's desire and need, and this was what we submitted, is Canada's desire and need to try to break up these gangs that occur, say, in one federal institute. Their solution is to splinter or fracture the groups and place them in other places. For women, that's very few places. There's Quebec. They basically take the group and they spread them across the country. Well, essentially what the impact has and what the academic evidence we put before them was this has actually helped the spread of gang involvement. And so our target in making submissions on that was as it relates, and you'll see this when you're talking about sex work as well, is the harm it causes to family, because provisions of the legislation looked to criminalize people that were assisting. So for example, what if the person who's getting you into a gang is your brother, your 19-year-old brother? All of a sudden they are going to get a larger sentence. And so there's a failure to look at the actual social implications all around. And so that was one of these other acts that has had a huge impact. And the criminalization as it relates to Aboriginal women is often when community members come back is that type of family involvement that brings the women in the community into these realms and into these the criminal organization circles. Our position, regardless of what we've advocated for or made submissions on, is always not to over-criminalize, not to criminalize. In fact, we've been arguing since like the early 90s that putting an individual into custody does not rehabilitate them. It does not put them into a place or space where they return to the community in a good way, somehow solved all of their problems, addictions, or substances, and ready to, roll. What happens is they go into custody and they come out, best case scenario, no worse than when they went in, but more often, much worse than they went in. With exposure to a substance that they had used, potentially with exposure to diseases such as Hep C and HIV because of sharing needles and not having proper things. And of course, coming out having tried substances they never had or alternative to substance because they can't get substances, and affiliations with criminal organization. Then they come back to our communities, not safer streets and communities. Despite the decrease in serious criminal involvement that is known and experts speak of, these laws got shoved through, pushed through, despite people going and speaking and making submissions, despite case law. And that gets us to, I'm going to talk for Bill C-36. I'm not going to spend a lot of time on this because I have an expectation that Chanelle will be spending more time on this. But, Aboriginal Legal Service was an intervener at the Bedford case, and the arguments we were making were in relation to liberty, Section 7, constitutional rights, to safety and protection, so that sex workers have an ability to put into place mechanisms and ensure that there are safety checks. This was a big thrust of the argument, was that the life and liberty of sex workers had to outweigh any potential nuisance that street noise or seeing street solicitation and what that meant in communities. So Bedford, for some people, we were on the side that the decision was made on. And so for some people, it was a huge win. And it was a huge win because of what the Supreme Court had to say. Some argue that the Section 7 argument wasn't a really strong one, but that the end result was good because it put a priority on the sex worker safety or individual safety as opposed to public nuisance and these other things. And so, of course, then comes Bill C-36, which is the new laws, sex laws, and essentially, and again, I don't want to touch too much on what Chanelle might be covering, but Stella just released this great series this great series of information cards, and they talk about what the old law was and what the new law was, and often you'll see it's the same law repackaged. And so when the bill passed through and the law came into effect, essentially what happened was the same provisions we were arguing about in the first place, 213 about communication in public space, it exists again. There are some parameters around it as it relates to a sex worker in terms of what he or she can do and where they can do it, but what it doesn't, but now all clients are criminalized. So any of the harms that were put before the Supreme Court, and the Supreme Court decided, clearly violated their liberty rights, has now just been changed to law. So they flipped maybe some of the onus and responsibility on who's liable for what, but the end result is the same. And so Stella's quote is great, and I love the part that they talk about is the impact of the law. So they have like little call blocks on each. I'm sorry, this is black and white. There's a very beautiful, colorful. They're plain language. They're great for clients. They're great for anyone to understand. And they have a section on impacts. And so, for example, the fact that clients are now criminalized, it still criminalizes sex workers in various ways. But the pure fact that when clients are criminalized, then one of the impacts is that when clients fear detection by police, they may avoid visible areas where sex workers may prefer to work and may rush into quick initial communications instead of taking the time to put safety measures in place and do the proper checks. So essentially, we know what this means. It means the work's going to be in darker and less populated areas where sex workers are more vulnerable to violence. They'll have less time to screen potential clients, and they'll work longer hours more often to generate more income because they're not doing it in a place where they can partner, where it's more visible, or there's easier access. That's only part of this law. There's tons of sections on what's unlawful in terms of advertising. You can't advertise for other people. You can't work together even if you're a sex worker yourself, because then you potentially go into the areas of law that say you're benefiting off of someone else's sex work. And so, if anything, the end result once the legislation is put through is way worse than pre-Bedford. And so, again, but in your part, why does it matter from an Indigenous or Aboriginal perspective? Again, Aboriginal women are overrepresented as street-level sex workers or survival workers. And so, essentially what ends up happening is they become more at peril, they get pushed in corners. And I mean, this is so often said, I almost hate to say it because it's becoming cliche and feels disrespectful, but all we have to do is think of victim. All you have to do is look at the composite poster of when the case was going through, and then also during the Opal inquiry. And when you look at that composite, it's predominantly Aboriginal, and that's but one example. The Zero Tolerance for Barbaric Cultural Practices Act, I'm going to leave this in your realm because you're going to do much better, except to say, and this is the only thing I'm going to say about it, because there's someone who's much more expert on it here than me. But if Canada has not learned, the Canadian government has not learned from, or have any sense or concept from lived experience of policy, law, and legislation in this country, how harmful this act will be, then it's absolutely ridiculous. We need to be questioning, why is our government getting bad legal advice? Why are we paying tax dollars to pay for these types of advice to be given to them? Because if we haven't learned from, for example, the Indian Act, which still exists in 2015, that taking law and placing it specifically on one race or one group, and including things like banning practices or prohibiting cultural practices in the group, doesn't have an adverse impact or effect on entire communities and generations, then they've learned nothing. So apologize 100 times for something, say, oh look, we've made a mistake, but they're about to reinvent mistakes. By placing certain parameters and not learning from their mistakes, the government is essentially saying, oh well, this is barbaric by our standards, so it must be wrong. And so when I say this is all I'm going to say about the Barbaric Cultural Practices Act, we've had our potlatches, our sweat dances, our sun dances, our thirst dances, and tons of our religion banned. Both first banned, then prohibited in law. And it's taken years to regain those cultural practices back, and that's only scratching the surface. Within the Indian Act and the Criminal Code, the RCMP and police enforcement had abilities to take all of our religious paraphernalia away from us at points in this history that now sit in museums across the world that we're still fighting to get back. And that's only those objects. The impact, the very human impact of things like the Indian residential school that sought to save the child and kill the Indian, and that full sort of foundation of policy and law to assimilate Indians, if we have not learned from that, then we have a problem. And to let this act go through, sort of unquestioned, thought against, is problematic. there's a live example. And quite frankly, where is Canada? And this is me disclaiming from Aboriginal Legal Services, but my own personal opinion, who in the hell does Canada think they are to decide what are best practices when they themselves have been such violators of human rights, and particularly Indigenous rights in this country? It's unreasonable. Bill C-51, the Anti-Terrorism Act, again, I'm not going to spend a lot of time on this. I think we're all still just reeling by the fact that it passed earlier this week. But I'll tell you what I do know. I know that a number of my colleagues that are as vocal as I am on a number of issues, such as missing and murdered Indigenous women, or such as children having equal access to care and education, are on CSIS watch lists, on RCMP watch lists, are followed and surveilled. And that was before Bill C-51 came in. What happens when the government has and gives authority to places like CSIS to act like a police agency without making, but still allowing them to have a secret sort of mandate? You know, and I'm sure I'm singing to the choir in the law union about the issues this raises. But from an Aboriginal perspective, the three big things that I see it being very harmful for is, one, the environmental or Aboriginal treaty and Aboriginal rights. So if you have a legitimate constitutional right that you are standing up as a group, and whether it's a peaceful protest, whether it's a road blockade, whatever it is, you're asserting a legal constitutional right or an environmental right, all of a sudden the scrutiny that's going to occur, particularly to Aboriginal protesters, which, by the way, doesn't have a good history of policing to start with. Aboriginal people are over-policed when it comes to them trying to assert their rights, and under-policed when they actually need access. And so the fear being is there's going to be yet more over-representation or over-policing of people who are essentially just trying to assert their rights. The second part of that is the advocates. Those advocates who are being surveilled for doing legitimate work. Some of those are professors with tenure, there's PhDs, there's lawyers, there's a whole host of people that do things like speak, like I am today, who now will have privacy interests. And without the ability to communicate and educate and raise awareness about the issues that Indigenous people are actually facing from a legal perspective, or feeling stifled or feeling worried, is not a good place to be. It's in a place of fear. And the third point is, it's just insane. It's insane what powers will be given to any person, not just an Aboriginal, like in relation to the privacy rights of any individual, not just an Aboriginal individual. But again, you know, you take the base knowledge that Aboriginal people in Canadian law and policy there's only been an attempt to assimilate them, and where there's been resistance, there's been punishment. The laws have, you know, historically and over time been punitive towards Aboriginal people and seen them over-incarcerated, over-victimized. So when you ante up or raise a higher level of surveillance, I fear what that means for any Joe public, but particularly Aboriginal individuals. And now I'm just going to turn to a couple of things, because I have about 4 minutes left. So I'm going to turn to a couple of things about, you know, so I've just told you all this awful stuff about the toxic legislative environment that we live in, and what does that mean? And I've sat here and said, well, you know, we go and we tell them every time how this is going to hurt, and they still push it through. And so you think, oh, okay, well, where does that leave you? Does that mean it doesn't matter? Because it does matter. Acting out, speaking out, talking out, writing these notes, it matters. Going to Senate standing committees, getting a deputization, they matter. They matter even when we know that a majority government is going to push something through. Why? Because they create a public record. When you create a public record, it's something that gets relied upon in case law in the future, in the public awareness and knowledge. There's a strategic approach that must be taken. So that's one thing. The other thing is, we have a huge amount, as it relates now, I'm going to turn a little more of my attention to missing and murdered Indigenous women. And so, because in this legislative environment where we have Aboriginal women overrepresented criminally, over-victimized, and over-surveilled, it's important to understand that the implications of colonial law and what colonial law has done to Indigenous women, we have international recognition that there's something wrong going on. So again, Canada, you know, standing up and saying, oh, we're great at human rights, we're the standard, we're the peacekeepers. It's not flying as far internationally. There's been a lot of international work done on this in this area. No More Stolen Sisters with Amnesty International has done a lot of work and put out a lot of material. The Native Women's Association of Canada did the Sisters in Spirit campaign, and it began in sort of full force back in 2005, 10 years ago. And of course, they came up with a database, and they came up with stories. And so the Voices of Our Sisters in Spirit is something they released in 2009 in 2 volumes. And it was the stories of women who were missing or murdered and their cases were unsolved. And of course, 2010 comes along, and the government in the throne speech says it's going to dedicate $10 million towards this. And then basically reneges immediately and says, oh, well, we're going to give the RCMP $4 million for missing persons database, not particularized to Indigenous women, not particularized to women in general, just missing persons. And so the Sisters in Spirit collaboration to end violence comes out in 2011, and at one point, the government was telling NWAC they couldn't use the term Sisters in Spirit, which is crazy, okay? But we will not continue our funding if you're going to keep, promoting this, because it was getting traction with the general public. The general public was starting to listen to the issues of murder missing women. Internally, we've had a lot of things happen. We had Forsaken, the report of the Missing Women Commission Inquiry, released in November 2012. The process itself was very problematic. It didn't have representation for First Nation or Aboriginal people. It had like 28 lawyers for government and police authorities. But some of what Commissioner Opal had to say and some of the research and information was actually quite useful and has been useful. And I know that, for example, we've used it for the purposes of demonstrating things or for case work. But again, Amnesty, as well as the UN, Special Committee on Violence Against Indigenous Women, and the Special Rapporteur, repeatedly in the last 5 years have been saying there's a problem in Canada. There's a problem in Canada as it relates to this Indigenous women. There's a problem in Canada in relation to how the government is treating the First Nation peoples and not ensuring people access to education, water, all sorts of things. So it's important to know that making noise still matters. And it matters on many different levels. It matters sort of like, when I speak particularly with youth, the one thing particularly about murdered and missing is I'm like, you need to be having these, what I call coffee table talks. You need to be talking to your parents. You need to be talking to your sisters. You need to be talking to your friends, because you're only going to get traction. You need to make sure you're in the world of technology, retweeting or liking things on Facebook that speak to this, because as a woman, regardless of your background, regardless of your previous race, it's almost impossible not to feel for missing and murdered women. And so to understand the gravity of the situation is what's really important. And so that rumbling, whether it's at that very kind of grassroots, let my whole family know about it, because when I go into a room and I say to people, how many people know about the Indian Residential School? If I'm in a group of mature people, like 5, 6, 7 hands come up. Since the TRC, more hands come up. But if I'm in a group of like kids who are grade 10 or 11, everybody's hand goes up. So information is power. It really is. And it is the thing that is cultural change. What else do we know? Well, the Legal Strategy Coalition, which is a number of people, I see some of the people in the room actually as I'm looking around, that are part of the coalition, is a collective of lawyers, activists, researchers that have released. So recently there was the Roundtable on Missing and Murdered Indigenous Women, and the Roundtable was the government meeting with who they selected as First Nation or Aboriginal representation. The families all went to Ottawa, and not all, a number of families went to Ottawa, and like the day before the Roundtable was about to begin, we're told they were going to get to have 4 representatives with the ministers. So you've been fighting to find out information about your missing daughter of 15 years, and the day before you think you're going to have some recourse, you're like, oh, I'm sorry, we're only on 4 people here. And this is problematic because this is the government's approach always. It's this old conquer and divide attitude. And so what happened was the Legal Strategy Coalition released a report right before the Roundtable, and we heard that from participants on the Roundtable that it helped them because it armed them with information. And what, just in a nutshell with the 30 seconds I have left, basically the report came out to talk about, because the Canadian government keeps saying, we can't have an inquiry, we don't need to have an inquiry. We've already researched this to death. We know there's all these reports. So the report looked at the 49 reports that the government was relying on, and 10 additional ones. And they looked at the recommendations that have been made, and they grouped the recommendations. And then they looked at how the recommendations have been implemented and by what actor, what government actor. And what the report found was 700 recommendations largely unanswered. Very little implementation. One of the biggest ones being a national inquiry. And this is what I'm going to close on. The national inquiry is something that a lot of legal advocates are asking the Canadian government to do, and it goes back to this having a public record. We can't just be talking about this in closed rooms or sitting around a table. We need action, and every Canadian needs to know what's going on. If we don't capture this information, there is no record. So outside of the room or in the room, you're going to see these. This is one small thing you can do. It will cost you a stamp and signing your name. And then it goes to, actually, it won't even, oh yeah, it's not, the problem is it's not going to the Prime Minister's. It's going to Amnesty first, and then they give it to them in batches. So if it was going to the Prime Minister's office, you would have to do the postage. But putting a stamp on this, signing your name, they seem a little dated because they're from last year, but they're basically saying we need a real action plan, not the kind of glossy covered one you put in, and that we need a national inquiry for missing and murdered Indigenous women. And it's grassroots level that have been raising this issue, not the legal action, not the political action.